Section 2 defines a retired president as a person who, having held the office of deputy president, has ceased to hold office as such in the manner specified in the Constitution. The interpretive question that arises is whether a deputy president who ceases to hold office by reason of impeachment can be deemed a retired deputy president within the meaning of the Act. Whether courts can legitimately interpret impeachment as retirement is a weighty and novel question. None of the parties address us on this issue. We are therefore of the considered position that it is not properly before us to pronounce ourselves on the same, for that will be presumptuous and will amount to stepping beyond the pleadings and the submissions of the parties. Accordingly, we decline to make any findings on this point. The parties are at liberty to pursue the matter further. An order of mandamus was sought to compel the National Assembly and the Senate to promulgate a constitutionally compliant procedure for removal of the deputy president by impeachment. We find this prayer to be merited. For clarity, the lack of such legislation per se does not, however, impugn the instant impeachment proceedings. Next, having found that the fair trial rights of His Excellency Gachagua were infringed when the Senate declined to allow the adjournment, that is in itself is a vindication of His Excellency Gachagua. We, however, hasten to add that the violation does not have the effect of quashing the Senate's resolution to impeach His Excellency Gachagua for precisely the same reasons we have provided with respect to the finality of the impeachment process. If the Senate's resolution were to be quashed or set aside, then by operation of law, the status quo ante will be restored, thereby effectively creating a scenario where there will be two deputy presidents in office at the same time. The impeached deputy president, reinstated by judicial fiat, and the successor duly appointed under Article 149, Sub-Article 1. We have no doubt that Kenyans did not intend such scenario, and the Constitution does not contemplate dual incumbency in the president. Accordingly, while the infringement of fair trial rights is acknowledged and vindicated, it does not undo the impeachment itself. The appropriate remedy lies in declaratory reliefs and damages in it to vindicate the Constitution, not in quashing the Senate's resolution. In light of the foregoing, that is not to say that His Excellency Gachagua has no constitutional remedies given the violation of his rights. As we said, we are convinced that this is a case where the infractions on the part of His Excellency's right can be adequately vindicated by way of appropriate declarations and damages. Applying Gitobu Manyara's case, it is our position that the violation of His Excellency Gachagua's fair trial rights during the impeachment proceedings calls for a remedy that goes beyond mere acknowledgement. Declaratory relief serves to formally recognize the infringement, while damages will provide redress and underscore the seriousness of the violation. This amount is not intended to compensate for the loss of office, but rather to vindicate the Constitution, restore the dignity of the affected party, and deter similar infractions in future impeachment proceedings. Lastly, we find that since most of the prayers sought in the consolidated petitions have failed, coupled with the public interest nature of this matter, parties herein ought to bear their respective courts. Given that the Gitobu case was resolved a decade ago,